everybody. Good morning. Good morning. Thank you for coming to the second session of the final day of the conference for the Home Care Association. I'd like to welcome you to today's session, which is the evolving view on overtime pay for live-ins and employee screening using criminal records and related legal landmines. My name is Denise Benura, and I will be your facilitator for this meeting. Just to let you know that there are no, this is an informative session, so there are no evaluation forms to be filled out after this session. Okay? So please join me in welcoming speakers for today. Chris Meyer, who was scheduled to speak with us, Todd will discuss. Unfortunately, he will not be able to make it. He has other commitments right now. However, we do have Robert Gaines, the Director of Wage and Hour Compliance of the New Jersey Department of Labor. He works to ensure and enforce the labor laws that address conditions of employment and the method and manner of payment of wages. Bob will co-host this active Q&A session and discuss the unique nature of paying live-in workers. Welcome.
Yeah, I just apologize on behalf of Chris and Sammy, who are stuck in the same trial. So, but actually works out better because you really want to hear from Mr. Gaines anyway. So we're going to do this somewhat informally. The one thing I did want to tell you though, the packet of material that was distributed does have the April 14th letter from Mr. Gaines, as well as the wage and hour regulations in it. So if you didn't pick that up, you may want to get that before you leave. That's the extent of my presentation. You want to know the joke?
Well, I guess I'm up. Good morning, everybody.
Good morning.
Thank you for inviting me. I appreciate that. I've done a few of these talks to the health care workers. They seem to go pretty well. A lot of questions. A lot of information I have to share. Within the booklet, I did send some material out. As Todd made reference to the April 14th letter, which I'm sure you're all interested in. If you haven't read it, please do that. There's also a document in there I forwarded as to how to get a hold of us at the Department of Labor Wage and Hour. It's got all the information on there, how you can reach us on the web, our addresses, phone numbers, everything of that nature. Just so you know, we do answer the phone. We don't have machines to answer the phone, so whenever you call, there will be a live person on the end. Feel free to call us for whatever you may want to discuss. What I'm going to start off with this morning is a couple of bullet points as far as the department is concerned, what we do and how we do enforcement. The first one will concern basically everybody here who's in the room, relatives, friends, anybody who's out there working. It's the minimum wage law. If you're familiar or not, but about 2 years ago, the government put on a referendum for the voters to pass whether or not they're going to raise minimum wage every year, and it went into effect. It started out at $7.25, it moved to $8.25 every year. At the end of August, they have to do a review of the consumer price index for the area to determine if there will be a raise in the minimum wage. Basically, it went up a total of 13 cents from $8.25 to $8.38. This year, come August, we're going to do the same thing. We'll do that from now on until the voters choose if they so determine to change how the minimum wage is going to be determined. We are required by statute to let the public know what the increase is going to be by September the 30th, and it goes into effect every January. So, not that I know what it may be, but this year may go up a small amount because of the way the consumer price index is moving this year. But expect that to come into effect, like I said, January the 1st. One of the other items that is of, I think, great interest to everyone is a new law that was passed effective March the 1st. We call it Ban the Box. It's basically Opportunity Compete Act. What it states is that you cannot ask in the first interview process to a potential employee if they have a criminal background, and unless you are required to do so by law. There's some agencies that require this. If you're going to try to become a policeman or a fireman or whatever type of work requires in law, working for a bank, and it requires within their statute that allows you to ask that question in the first go around, you can legally do that. As of right now, it entails pretty much everybody else. We're in the process of writing the regulations. We have closed the open comment period. We did receive a lot of comments from various areas, some good comments. One of the questions that they did have was pertaining to the number of employees over the time period that you're required to have, whether or not you meet the classification. I don't have it in front of me, but I believe it's 15 employees for a 20-week time period. Once you meet that, then it is the breaking point, either whether or not you can ask it in the first interview or not. And again, this pertains to the first interview only. So if John Doe walks in the door and you have him fill out an application and that little box is on there and says, do you have a criminal background? That's considered the first process of hiring or interviewing them, and that's against the law. That's why they call it ban the box. After that, if they come back for a second interview, you can ask them anything you want to, basically pertaining to that. And the reason this law was passed is to give these people an opportunity to get their foot in the door, to be seen, to be talked to, rather than submitting an application and say, okay, because you checked off that box, we're not going to bother looking at your application. So that's the purpose behind the statute. Again, it affects every employer in the state of New Jersey unless you meet that criteria, the threshold for the number of employees for the weeks involved. There's another one that we also have is been on the books for about 3 years. If you're applying for people to come to work for you, it basically says you cannot ask them whether or not they're unemployed. Like I said, it's been on the books for 3 years. We've had 1 complaint filed. We look at it as maybe it's not a very good statute, but it's out there to protect the people. And this particular advertisement said, if you're unemployed, do not apply. Someone was looking for a job on the internet. They found it, they filed a complaint with us. We went and investigated it. We assessed the penalty. They disputed it. It went as far as the Superior Court. Okay? This company was adamant that they were doing correctly. The initial penalty was $1,000. We reduced it to $100. How much do you think that cost an attorney fees to run this all the way up to Superior Court? Okay? I know it's the principle of the thing, but it's a pretty simple document as far as we're concerned. It said don't apply, and this is what we assessed them for. But the reason I'm bringing that up is that you either are involved with hiring people or interviewing people or putting ads out there for people. You know, you cannot put in that advertisement to say that unemployed need not apply. Okay, it's against the law. We enforce that. It's not dealing with wages. Most of the stuff that we enforce deal with wages, but some of these new laws have nothing to do with the actual person earning wages. It's them having the opportunity to go in for a job interview and have the ability to compete and try and get a job. There's a question about travel time, which I know I'm going to get a lot of questions on. If you look at our statutes and regulations, travel time is really not defined anywhere, so if it's not, then we will refer to what the federal government has. What we do have is what I consider 2 different things. We have a commute time, and what we have is a travel time. Commute is when you leave your home and you go to the place of business. That's commute. You're not required to be paid for that. When you leave that place of business and go home, that's also commute time. What the question arises is, what is then travel time when you go to point A to point B to point C? Okay? We're saying if it's on the course of the business, then that employee has to be paid for that time period. I know the question's going to come up and say, okay, if I have an appointment at 11 o'clock in the morning, and I have another one at 3 o'clock in the morning, and I'm going to have to travel between stops for 30 minutes, do I have to pay them for those 4 hours? And the answer is no, okay? You have to figure out how much time it's going to take them to go to A to B and pay them for that amount, okay? That's no different than a person who works for a heating and plumbing company, and they'll go to your house today at 2 o'clock, and my house at 4 o'clock, and someone else's house at 6 o'clock. They're on the clock all the time, so they have to be paid for that. Now, if there's such a great time in between the stops that it's feasible they can do what they want to do, then you're only required to pay with the actual computed time of what you compute, okay? The state does not compute this. You as the employer need to compute that. So make a determination if they have to travel 15 miles, and it's the middle of the city, it's going to take X amount of time. If it's between Millville and Vineland and they have to go 10 miles, it's all on rural roads, it's going to take them 10 to 15 minutes. But you as the employer need to compute that for them and say, okay, we're going to pay you this dollar amount. And I know that's going to raise some questions. And I have no problem answering any questions anytime you want to ask.
A question on that.
Yes?
Does that need to be stipulated then in payroll?
Well, obviously you need to devise a payroll that this is how we're going to pay them. Someone has to determine what that time of travel is. Either it's going to be the employee on their log sheet that they keep, or when you send the assignments out to them and say, okay, you're going to be at A at 11 o'clock and B at 3 o'clock, and we know it takes 30 minutes to travel, so we're going to pay you 30 minutes. So make the employee aware.
Yeah, okay.
Yes.
So you have to pay the time and the travel expense, both?
Travel expense is not required in the state of New Jersey.
Okay.
Neither is vacation, holiday, sick pay, or anything else like that, unless you happen to work in 7 cities in the state who have now passed a sick time law that is enforced by those cities, okay? And I think the criteria is pretty much all the same. The major cities in the state, Trenton just passed theirs, those went through the court system, it was upheld. Newark, Jersey City, Trenton, and I don't know what the other 4 are, but basically they all say the same thing. If you work for an employer that has X amount of employees and you earn so many hours, I think it's 1 hour for every 30 hours of work up to a maximum of 5, okay? That's the only sick time laws that exist right now in New Jersey. Unless you're an employer who offered to the employees, and if you do that, that becomes part of the agreement that you have with them, and you have to adhere to that. And I would suggest if you do that, you put it in writing, so everybody knows what it says, and there's no interpretation of a verbal commitment to say, okay, I'm going to hire you, and after a year, you're going to get a week's vacation, but all of a sudden the employee comes to me, and in 10 months they want to get paid for it, and then the next month they leave. You know, what happens here? Now you don't have the policy that you put into effect. But as far as expenses for travel time, that's up to you. You're not required to pay that under New Jersey law. They can claim it on their income tax. Do 2106 and put it on their income tax. Yes?
The sick time law applies in those 7 cities?
I'm sorry?
The sick time law applies to companies based in those 7 cities?
The actual employees working in that city, and that's a question, okay? They have to be in that geographical city itself. And that comes up with the ban-the-box law, because there's a question. I'm located in New Jersey. I have 10 employees in New Jersey. I also have a location in Pennsylvania and New York, and each one of those have 30 employees. So the question is it the 70 employees, or is it 10 employees that work in New Jersey? And that's going to be tackled when the regulations come out. And that was a question that was posed by every company or person who responded to the open comment period, asked that particular question about the number of employees. I don't know what the law looks like as far as a sick time policy is concerned. You need to actually go to that particular city and see what it says. And once you get that, I would suggest you talk to your attorney and say, okay, is it because we're located here, we have satellites all throughout the state, or is it only for the workers within this city limits? Anybody else want to ask me anything while we're rolling along here? Gotta have some questions. Yes?
So, for Jersey City, you pay sick time, but for people who, what is it? So, if somebody's employed, let's say in Union City, and they have people work in Jersey City, they have to pay them sick time. That's kind of what we figured out. We were never really given too much guidance by it, but we just wanted you to pay them sick time in Jersey City.
That's my understanding.
So,
and the reason I say, let me interrupt it, because we don't enforce that.
Right. I mean, it was just unclear by all the standards.
And that's why I went to the court system when Trenton tried to pass it, and they had the business industry people and a few other major employers in the city of Trenton take them to court, and the court actually upheld the law.
So here's my question though, is now what if the council of Jersey City wants to go into this business in Union City to do an audit? Do they have the jurisdiction or the authorization to go into a different town to do an audit based on nothing in their town? That's my problem with it. I would say
I don't know what authority they would have to go into anybody's place of business and do an audit. They don't work for the state of New Jersey and enforce labor laws.
Right.
They can obtain records from public bodies, but not from individual companies under the Open Public Records Act.
Okay.
But as far as doing an enforcement of a law that's in Jersey City for Union City, that's like us enforcing a law that's in New Jersey and going to Pennsylvania. We don't have any authority.
Okay. I agree. I'm just saying.
And I would say it's the same thing. But again, I'm not an attorney, so I can't tell you that or advise you that. But I would suggest, as I do to most people when they ask legal questions like that, talk to your attorney and see what they say. But from my experience, our laws are not effective in New York, New Jersey, Delaware, anywhere else. It's just within our boundaries. And we have had some statutes challenged like that when we tried to enforce it on companies outside. And the Office of Administrative Law says you can't do that. Because once you reach the boundary of New Jersey, your law ceases. I mean, we try and dock or send subpoenas out to companies outside the state of New Jersey, and we know it's not going to hold up water in the court, but we still try to do it to obtain records to do that. Nothing says you need to live in your door.
That's
I understand what you're saying, but if you're inside that city that has that particular statute, then you're gonna be bound by it, as long as you meet the criteria that's spelled out in there. Within the packet, you have the letter that's dated, I believe, the 14th. Okay. This came about as some various enforcement policies that were set back in 2008 by a former director, which he didn't have the authority, nor I had the authority to set programs up like this. Basically, I've been told by a regulatory officer and by our Attorney General's office that in order to set regulations of this particular nature, and they would consider this a regulation, it's got to go through the process, open comment period and everything else like that. This is just something that they thought of to try and help out the industry, because we know how you get paid with Medicaid and Medicare, and you know, the answer is that, well, the workers always want to know what they get paid per day. Well, you know, the wage and hour laws and the wage payment law say that, you know, you need to establish a daily rate for them, or an hourly rate, and by pay for the living. So this letter says we don't accept that anymore. The law hasn't changed, okay, from day one. And this is created to benefit everybody out there trying to determine what they're going to pay. It basically says you establish a wage rate for the person. If they work more than 40 hours in a work week, which is 7 consecutive days, 168 hours, they have to get paid at time and a half the regular rate. It's your responsibility as the employer to determine what the regular rate of pay is and then pay them overtime if they work in excess of 40. Now, understand, I do not enforce federal labor laws, and I know January the 1st is how the big controversy got started, because they passed all these new laws and they've done away with some of the overtime exemption, and the record keeping now is more stringent, obviously, if you have a live-in and they're there and they're required to get X amount of hours off, and that's all under the federal government. I understand that you've had a presentation by them,
Yep.
and hopefully you asked them a lot of questions, because my answer to all that stuff is, well, you have to talk to the feds. Our regulation still sits there and says you only have to count for 8 hours a day. That's all we say. But because now the federal government is more stringent, you have to adhere to that, obviously. Not only for the record keeping, but also the payment of wages and everything else that they're coming under. I've talked to my counterpart who works out of the Lawrenceville office as a director there. She tells me that the 2 points that's under appeal in the court system is still out there, hasn't been decided yet. So out of the 4 that they tried to put through in January the 1st, 2 of them are effective and 2 of them are not. So they're still waiting to hear on those things. And I think the biggest one was the exemption for the compassionate care overtime that they were looking at. So that's still hanging out there, and my understanding is it went into effect January the 1st. They weren't going to start enforcing until July the 1st, so I don't know if either going to do that. But as far as questions are concerned pertaining to that, I'm sure you probably got all the answers from the federal government when they were here. But again, New Jersey has not changed as far as we're concerned. The only thing we did was take back this 5 and 3 deal, which shouldn't have been put out there in the first place. I know you're a pretty good size organization. In the past, we have had organizations go to the legislatures and say, we would like to have this put in. There's one currently out there for the trucking industry. They basically got an exemption for overtime pay for their drivers if they are in the trucking industry, and if they pay them at least an hourly wage rate of time and a half the minimum wage. So whenever our minimum wage goes up, then their salary is going to have to go up. But that was put through the legislature because they took a group of people like you with your association and said, okay, legislature, we have a problem here determining how we're going to pay our people. We would like to have this put through specifically for us. There's one out there for the healthcare workers, okay? Mandatory overtime. I don't know if you're familiar with that one or not. If you're working in a hospital or a place like that and they ask you to stay for overtime, there's certain criteria they have to do before they can mandatorily keep you there, which means they have to go to other people, they have to go to outside agencies. Unless you volunteer to do it, they have to take all these steps before they can require you to stay there. Again, nurses associations and businesses of that type went to the legislatures and said, we need this to protect our workers. There's one out there right now, it came across my desk yesterday, for camps, summer camps. I know it doesn't affect most of the people here, but there's a statute on the books that we enforce that says summer camps, as long as they're for like a religious organization or something of that nature, they're exempt from overtime. Non-profits exempt from overtime. Well, the people that came to us said that we are a for-profit camp, so we would like to have the same exemption. So they went to the legislatures, got a couple people to support a bill, and I have to do a comment period, and I'm gonna go back next week to say whether or not we support it. But their position is because the nonprofits and the religious ones have an exemption, and we do the same thing that they do, we want the same exemption. So we don't know if it's gonna go through or not, but basically they're trying to level the playing field for as far as they're concerned. And the reason I'm throwing it out is because you may want to do the same thing as far as you're concerned with, how you collect money from Medicaid and Medicare and how you pay your living people. That's only a suggestion. I'm not going to tell you what to do, but this is how you get laws changed. As of right now, like I said, our law hasn't changed. So that may be a thing to do if you want to get together and say, okay, we know a legislature who's going to support us, no matter which side of the table it may be on, and say, okay, this is what we want to propose. This is the problem that we're having. This is what we'd like to propose, and see if we can get through the legislature. Okay? So that's an idea of correcting the matters that may take place. But as far as the records that you have to maintain and everything else, you're looking at basically two different enforcement agencies, under the Fair Labor Standards Act of the federal government and under New Jersey wage and hour. So again, we fall in the same scenario with minimum wage. We always say whichever is more restrictive, more stringent, that's what you have to adhere to. Clear example is minimum wage. Federal government is still $7.25 an hour. Pennsylvania, $7.25 an hour. Okay, we're at $8.38. You go to California, I believe Los Angeles just passed one for the city of Los Angeles, $15 an hour.
Wow.
So this is what the movement is across the country. You see it every day in the paper. Everybody's talking about Walmart and McDonald's and living wage and everything else like that. Is your first job supposed to be a living wage? I don't believe so. It's supposed to start out and then work your way up. But that's not for me to say. We've already had that pushed through our legislatures to say every year we're going to look at the minimum wage and increase it. Now, if for some reason the government, federal government, passes the minimum wage that goes to 10.10, which they've been talking about, New Jersey would automatically go to 10.10. So just be aware of that factor. I know that President Obama's been talking about that in certain areas to raise it to 10.10, but if it goes across the country, which I personally don't think it will, because you have states that, like New Jersey, very high living, and you go to other states like Alabama, Mississippi, North Dakota, things like that. Cost of living is not as great, so they don't have to worry about the minimum wage as much as we do to try and help our workers and protect our workers. But if it does go to 10.10, we will automatically go to 10.10. I'm open for questions. I mean, if anybody want to ask me anything, go ahead.
I'd like to talk about timekeeping. So the live is in the home, and they do a bath from 9 to 10. They would need to clearly identify they completed that bath from 9 to 10. They rested, the patient didn't require any services from 10 to 12. So that's not compensable, I understand.
You're asking me about federal regulations.
Okay.
New Jersey says you have to get paid for time actually worked. That was part of my understanding, the new federal regulation went into effect January 1st about more stringent record keeping. And I was at a presentation a couple months ago where they were going over some of this stuff, and one of the things that I heard was if they don't have 5 hours of uninterrupted time, then they have to get paid for all those hours. That was one of the key things that I heard. And then of course, they went off about an hour and a half and talked about everything else, and unfortunately for them, thank God they went on before me because they really got beat up. And the reason I say that is because it was, it's new. It's been out there, everybody knows it's been coming for a year and a half. All of a sudden it hits January the 1st, and there's still all these question marks out there. So as far as the question you're asking is, I can't answer that for you other than to say that New Jersey requires you to pay for time actually worked. So if you're required under the federal government to keep more stringent records to show the bath time, the break time, everything else, we would go and look at that and say, okay, you recorded this as work time, you have to pay them for that.
So, but you would have the expectation that whatever tasks they're doing in the home, you have time allocated to those tasks to determine the 8 hours.
As far as New Jersey is concerned, as long as you can stipulate 8 hours. And see, that's the key. 8 hours is like an open book. They're there for 24 hours a day.
Right.
And we're only saying that you have to pay them for 8. Now the federal government, I know, is saying you have to pay them for more than 8 because you have to keep these more stringent, correct, exact records as to exactly what you're doing and how long you're doing it and everything else.
Just to clarify, when you say the federal government, do you mean if the patient is actually paying privately, or are we talking about if the patient is utilizing federal funds?
No. It's
Doesn't matter.
what authority or jurisdiction they have. Okay, we have authority in New Jersey, they have authority, they have a limit of, I believe, $500,000 of gross product or something like that. There's a cutoff figure for them that they start at, and most businesses hit that right off the bat. So they're covered under both. The problem that arises is now the federal government is much more stringent than we ever were, or still are. And now everybody's got to adhere to that. It doesn't say where the funds come from, it's just that how you meet this threshold. So, and you know, they've created a nightmare, and unfortunately, a lot of those people that I've heard talk, they don't have the answers because they're not getting them from higher up. Because you still have all these pending court cases and everything else going on. Even though they had that 1.5-year period to put it in existence, and then not going to enforce it for another 6 months. So you're talking about a 2-year time period that everybody know about it, and there's still all these questions. And we run into the same thing when we get lost. And that's why you have to write regulations.
I mean, it's very complicated. I mean, it's easy to figure out the bath time, but it's, you know, those 15 minutes where the patient says, you know, can you help me with my lunch? Or, you know, can you pull the laundry out of the dryer? I mean, it's just like, you know,
And
it's a nightmare to keep track of.
Again, what I've heard, it's like you're going to have a sheet of 24 hours and you have to break it down, all these little things that you do.
But if you were looking at just New Jersey,
Okay.
would you require that kind of documentation of time?
Or you just want
Or
in
do you
and out
just want
times?
8 hours?
Well, actually, we don't even say in and out times unless you're a minor. They're the only ones at the in and out times. It just says 8 hours a day. That's all it says. It's 8 hours a day. So to meet our criteria, that person's a live-in, and you're going to pay them for the 8 hours a day. Now, the dispute you're going to run into is the person who you're paying for 8 hours, and they say, no, I work 12 hours every day, and here's my books and records that I kept. Okay? And we would go look at those, because we have those happen all the time. We have what we call a wage collection section that basically is like a small claims court, where the employee can sue the employer and rehear the case. And John Doe employee's going to come in and say, okay, I worked on this construction site for all these hours. Okay, and I maintained everything, what I did, what day I showed up, how long I was there, everything else. This is my record. And I work with all these other employees, and they can verify what I did. And I go to the company records, and they only show 6 hours a day. If that person's going to file a complaint, they're going to have to carry the burden of proof to say that, yes, I did that. And they're going to bring witnesses and say, yeah, that person worked with me. We did all these hours. These records aren't right. And we're going to say to the employer, you owe them the money. And that can happen in the same scenario right here. That if you have a person who's working in the home, and they're going to keep these records to benefit themselves in theory, so they make sure that they get paid properly, they can present them to the state and say, no, I was working within 8 hours a day. Even though the law says you don't have to pay me for 8, I was working 12 hours a day, and here's what I was doing.
But what about the term engaged to be waiting? So they're technically working because they're engaged in the home.
Yeah, there's a couple terms there. I don't think I have the law book with me, but there's engaged to be waiting, and there's another one that stipulates that also. Depending on what you're allowed to do while you're waiting to be employed or engaged to be employed. A lot of that happens with people who get beepers. I mean, I know everybody's got cell phone now, so we used to have the beepers. My wife used to have a beeper and said you can't go more than 45 minutes away from the thing. And they paid her, not that they had to, they actually paid her like $2 an hour for being on call. But then as soon as the call came through, she got paid. The question that you have is, waiting to be engaged, well, I'm watching TV, or I'm sleeping, or I'm eating, I'm taking a bath as the worker. Am I still waiting to be engaged? And should I be paid for that? That, you know, to me, you have to look at it on each case-by-case basis. Make a determination of what they're doing, maybe even what the patient requires. I mean, the patient may be able to take care of themselves 80% of the time, and yet the living is still there all the time. So a lot of stuff is determining factors. To give you a blanket answer, you know, I don't want to do that because we would have to look at each individual one. I know you don't like that answer.
It's so gray. I mean,
Absolutely, it's gray.
It's incredibly difficult to meet this regulation.
It is.
It really is.
It is. And that's the problem that the federal government is having with this. Now all of a sudden they've taken this wide open thing and they've gone to this, okay, which nobody really had to adhere to before. And that's what's created the problem. Besides that, they've thrown out that exemption for, I forget what the term, compassion. Right. That's one of the things that's under appeal. And that threw out a lot of exemptions from overtime. That wiped out a lot of that stuff. That's why this record keeping came into effect and say that, you know, 5 hours, if you get 4.5, then you got to be paid for all that. And you got to keep all this criteria, what you do day in, day out. when you're working, when you're not working, and pay according to that. And the statement that the people made from the federal government said that there was a possibility you may have to pay them for 24 hours a day, depending on what they're doing and what records. And let's, be reasonable. Within 2 days, you've already hit over 40 hours, and everything after that is time and a half. And that throws it back onto the person who needs the care because they like that one person to be there all the time.
Right.
So you're caught between a rock and a hard place, and we understand that.
Very invariably consumer.
It is, because who ends up paying for it? And I know from what I hear from everybody, Medicare doesn't pay anymore. They're still at that flat fee for whatever they've been for years, so we're good stuck with it. The employee's going to go down, instead of $10 an hour, they're going to get $9 an hour or $8.50 an hour or minimum wage to cover that. So it's like a reverse process that happens, and we're all sort of caught in the middle of it.
So if you're doing that 5-3, you should stop that.
Yes. What I say is the law requires you establish a regular rate of pay. You establish as the employer a regular rate of pay, and once you hit 40 hours in the work week, you have to pay time and a half.
Okay.
How you get there is up to you. That's all the law says.
Okay.
Anybody else? I know there's a lot of time left. I'm just going to go over how we do an enforcement action in case anybody has had us visit you. Anybody? You don't have to acknowledge that.
We're hoping you don't listen to this.
Everybody, right? Okay. Basically, I have 50 field people. We're pretty much complaint generated. So unless somebody files a complaint and says, I'm not being paid properly, we're not going to probably be knocking on your door unless one of my investigators got a lot of free time and they can go out and do a routine. We do have something going on right now as far as one particular business is concerned where I've had all my field staff concentrate on this particular area and try and get inspection out for every one of them at least once or twice a week, but I won't discuss that type of thing. We receive a complaint, we have forms that they fill out, send in to us. They tell us who they work for, who they are, how long they worked there for, what are they looking for, okay? Not paid wages, illegal deductions, they didn't give me my vacation pay, I didn't get my severance pay. All this stuff falls under the authority of the Division of Wage and Hour Compliance. Okay. The complaints are forwarded out to the field staff. They will visit the place of business. They'll walk in or either call you up and say, I'm coming to do an inspection. If they walk in, they'll identify themselves. They'll ask to talk to someone who's in charge, authority, bookkeeper, whoever it may be, to ask for the records. If the records are not available at that particular time when they first walk in, they will leave an appointment letter that spells out about 25 to 30 different things that we are looking for. And basically what's required by law as far as your records are concerned, some information about the business itself, things of that nature. When they come back and do the inspection, they normally look for a 2-year time period. Okay? Minimum wage and overtime is covered by 2 years, so that's what we look for. We will attempt to, depending on what the complaint is for, we attempt to look at as many employees as possible. They will either ask for copies of the records or they will transcribe certain records. And within those records that they ask for will be probably the person who filed the complaint and other people who may be in the same scenario. So if the complaint happens to be for overtime, we make the assumption that everybody in that place of business may have a problem with overtime. Or illegal deductions, things of that nature. Or if it happens to be a last paycheck, we just may call them up or send them a letter and say, we got a complaint from this person, they didn't get their last paycheck, and we hear the side of the story. They will do a complete 2-year inspection. If they find problems, they do 2 things as far as they're concerned when they're there. They will write down all the records that they looked at, and they will have the employer sign that, and they also have what we call an alleged violation sheet. So if they see a problem there, they will check those things off. They will leave that with the employer also, and the employer will sign that. So part of that goes into the file. They will then submit that into the office. The supervisor will review it, make a determination everything is nice, complete, ready to go. If wages are found due, they will assess administrative fee on the wages. The law requires us to do either 10, 18, or 25%, depending on the number of violations that the company may or may not have had. First violation is 10, second one is 18, and third subsequent goes to 25. The assessment letter goes out to the firm. They have an opportunity to contest it. We ask for 3 things. Either pay the money, contest it, or the other thing is we want to have a conference. So if they want to have a conference, we will try and call them up, try and resolve the issue. If they pay the money directly to us, we send the checks out to the employees, we close it out, they're done with. If we can't resolve it informally, I have 2 hearing review officers who will actually send the company a letter, bring them down to Trenton, sit down and go over the whole thing, try and resolve it. Very rarely, as far as your type of business is concerned, will it go to the Office of Administrative Law for a hearing. Most of the time when we go over there, it's for the violation of the Prevailing Wage Act or the Contractor Registration Act. As far as what we call general enforcement, very rarely do we go over there. We were in court yesterday for complaints filed in municipal court for a repeat offender. When I say repeat, this company was around the block about 4 or 5 times for the same thing, didn't want to correct themselves. So we went to the Attorney General's office in the criminal division, and they said, no, we won't handle it for you, but this is what you can do. So we filed the complaints on our own in municipal court. It was heard yesterday. We ended up getting a consent order signed and an agreement that this company's going to pay all the back wages that we determined due. And then for future compliance, if they fail to meet this agreement, then we're going to go back and have the judge follow up with the consent order, which we used to do a lot years and years ago. And when we got the Penalty Enforcement Act, we sort of didn't have to do that as much, but this is the first case we'll probably proceed like this in about 7 to 10 years. But that option is available to us. We can't put anybody out of business unless you're doing public work, which I don't think anybody does construction work here. But that law is very stringent. We can actually debar a company from doing public work for 3 years, or we can remove their certificate for doing business and that type of work for 5 years. So that's a very heavy hit for that type of business. But as far as the type of people that I have here in front of me today, maybe consider a little more lenient as to what we can do. We try and work with you. You know, we're not here to put you out of business. We want to have people working. We want to have them get paid properly and move forward. You know, we're open. We can have people come give speeches for you, talks like we're doing here. If somebody calls up and says, you know, we're opening up a new business, can you come show me what to do, what I need to do? We'd be more than happy to do that. We have other agencies within the department that deal with taxes, unemployment, disability, workers' comp. We make referrals to them all the time. If our investigator goes in and sees that there's not workers' compensation or there's no disability insurance policies, we will make a referral to those other agencies, and they will follow up and visit that place of business. We want to make sure everybody's compliant with all the laws that we enforce, not only in wage and hour, but everything in the Department of Labor. I don't really have anything else. I mean, if somebody would like to fire away, please help yourself.
The first, second, third offense, you mentioned if an employee writes a letter and complains, you assume that's applicable to all employees. So if you find in favor of the employee that wrote the letter and you happen to find another one, is that a second offense? Or is
No,
that
it's all under the same investigation.
Yeah.
Right. And it's for gross wages that we collect, and it's a percentage of that. Okay. On the other side of it, we also have, under the Penalty Enforcement Act, where we can assess penalties for the violations of various statutes. And that also has like a multiplying factor in it, where we can assess per employee per week if we want to. So and that goes up to $250 for the first offense. And if we have subsequent offenses, which means we come back next year, the year after, and we find the same thing, we can go up to $500 per offense. So if we see 10 employees who haven't been paid for 10 weeks, we can actually do 10 by 10 times the 250 and assess that penalty. And obviously the employer has the opportunity to come and discuss, and we try and work with them to say, okay, this is your first time around the block, we understand what you're doing, we want you to correct it, we will reduce the penalty as long as you correct the matters that are involved with. Okay. Thank you. Okay.
I was going to, I don't want to cut off questions, but I was just going to pick up on something with regard, and this is a general comment, not just in this instance, but if you heard me speak about compliance and HIPAA and all that, talking about how to handle investigators. And just some general advice, because I think people don't realize this. If an investigator is there, it's because there's been a complaint, okay? So they're looking, and as Bob said, it may be, if they find a complaint with regard to a single individual, it may be indicative that you've got a similar problem across the board. They have jurisdiction over you. They have the right to come in and ask for those records. We get into these arguments about subpoenas and stuff. They have a right to come in and get records. They don't, investigators, whether it's the division, Department of Health, anybody, can't actually force you when they come in to do an interview, okay? And I have no experience with division. I have a lot of experience with board of medical examiners. And they will come in and they'll ask for a patient's record, and then they'll very casually say, mind if we talk about this? And the doctors inevitably go, yeah, no problem, until they get halfway through the conversation and they realize they got a problem. So we always try to advise clients, they have the right to come in and get the records, and you always cooperate. There's nothing to be gained by getting defensive and starting to fight with an investigator when they get there. We're always cooperative. But if they want to do an interview, it's typically best to ask to set up a time to talk about what the problem is, because you don't know what the problem is that they're looking for. They probably at that point have more information than you do. Also, depending on the investigator, you don't know who they're talking to. They may get to a lower level they may just talk to whoever comes out the door and they say, do you have anybody from HR? And somebody comes out from HR. You want to make sure it's worked its way up through management. So it's good to train your staff to say that if an investigator comes in and they want to interview, that they report up the line to let their supervisor know. Having said all that, and I always try to emphasize this too when I talk about this, you can't instruct your employees they're prohibited from talking to an investigator, because that comes back as obstruction of justice. So
and you don't want that.
If an employee really wants to throw themselves on the sword, and some burning desire to talk to the investigator, they have that right. But the better practice is, because when they come in, they know what they're looking for because they found a problem. It's better to find out what the problem is and then set up a time and speak to the investigators, when you have the full facts. Hopefully that'll help resolve it better.
Just be aware that we will not ask anything about HIPAA, okay? we know that. Our investigators do have the right to speak to your employees, okay? Under our statute, they have the right to do that. As Todd said, you may want to set up a time, put them in a room or something like that. I can tell you from past experience that most employees do not like talking to us when their boss is around, okay? Because the first thing that happens when we leave is the boss will go over and say, what did you tell them? What's going on? And this is sort of backfire. So, I understand they're fearful for the job. People need to work out there, and the employer might say, well, I don't need you here anymore because you came in late today. But the real reason is because you talked to the investigator from the state of New Jersey. Okay? But no, our investigators have the right to talk to their employees. And if it's a matter of setting up an appointment to do that, or going through HR to say, okay, we walked through the floor, we saw 6 people, we'd like to talk to them, we can do that. Okay? But we don't want to interrupt your business. That's one of the main things we do not want to do. In some places that we go into, we may not have an option, depending on what type of business it is. But we will try and set that up through either the manager or whoever's in charge for the day or whatever it may be. And other times, they'll just leave their business card, or they'll leave forms to say, okay, if anybody's got a problem, fill out this form, or give me a call and I'll come back, something of that nature. But again, we try and enforce the laws across the board equally for everybody. I know a lot of employers may not think that way, but we have a job to do too. And we expect that you as employers adhere to all the statutes that we enforce. And I can tell you that based on what we collect, not only in wages, but for administrative fees and penalties, there's a lot of bad guys out there, okay? Last year we collected about $8 million in back wages for New Jersey alone. 7,500 to 8,000 complaints a year received, okay? We live off of our fees and penalties. We collected about $7 or $8 million in fees and penalties. We are self-sufficient. We don't cost the taxpayers anything unless they're violating the law. Then they pay for our salaries. We actually give money back to the treasurer. So that tells you what type of, some of the employers that we have in this state. There's an underground economy out there. People are getting picked up on the corner. They're getting paid as day laborers. There's problems out on the farms when the migrant workers come up. I mean, it's rampant everywhere, okay? And we don't have enough staff. Federal government doesn't have enough staff to enforce it, so that's why we look to the employers to say, you're good employers, you have to adhere to the laws. If you have a problem, we try and work with you. But the repeat offender, we have no mercy for. Just as the example I told you yesterday. We got tired of this company, we went after them, and now we got a consent order again. So it didn't work out too well for them. Anybody else, anything? Feel free. I can't answer anything about workers' comp disability or anything else like that, but anything wage and hour, I think I can help you with.
Anything else about that, the topic about criminal background? That's just the first interview. That's the totality of that.
That's basically what it says, first interview, and also there's the criteria for the number of employees and how long they're working. So, I mean, the law's on the books right now. You can look it up. But as far as the regulations are concerned, I don't think they'll probably be out until, the register, I would think probably not until August. Because, they're still putting together what the comments were. And like I said, we got a lot of comments. We did. And they were very good comments. From concerned, businesses, some groups, some attorneys wrote into us who were up on all these labor laws, and wanted to decipher exactly how we're going to put it out there. We had a big push from the senator who wanted the bill passed. I know they met with us numerous times and the commissioner about how we're going to enforce it. We actually had to go out and create a new form for this statute. We threw in a couple other ones on there because what we had before was what was called a wage claim form. Well, this is not a claim for wages. So we have other laws that we enforce that are not dealing with wages themselves, so we put them onto this new form. So because of this being passed and the senator coming to the commission and everything, we actually created a new form for this. And we've had 3 complaints since March the 1st, all from the same person who does the same thing. They go on to the internet, the web, Craigslist, somebody's advertising for a job, lo and behold, you'll be there. Do you have a criminal background? Okay? Unless they're asking for a police officer's job or something of that nature, that's illegal. This person has filed 3 complaints with us. We have done an investigation, inspection, the whole thing. We have resolved 2 out of 3 so far. The 3rd one's just waiting to come in and we'll resolve that. There was a penalty assessed on them. I think one was paid $100, the other was $250, and the other one's still open. But this is what this person does. And when my staff call him on the phone, they ask him, what's your end to the means? And I think his answer was, well, I'm trying to get a job. Well, great, but it gives us something to do. We get the laws, we have to enforce them. It's like the one I told you before about, unemployed leave out of apply. It's been there for 3 years. We've had 1 complaint. On the other side of the coin, the enforcement of the wage portion of it, $7,500 to $8,000 a year. So there's people out there who are not getting paid, getting shorted somehow, some way. Okay, and that's what we do. That's our job. Anyone else? Within the booklet itself, it's like I said, it's got that April, I think, 14th letter in there. Please make yourself familiar with that. That's doing away with the 5 and the 3, and it tells you why we did it. Should have never been done in the first place. And the other item that's contained in there is our handout sheet as to how to get a hold of us and wage down. So if there's a question you want to ask in front of the people here, I'll be here for a little bit. You can talk to me personally if you want to. You can write into us. We have an email address on there. We have phone numbers. Questions about whatever it may be. If we can't answer as far as wage and hours is concerned, then we'll direct you to the proper agency you may be talking about. Anyone? Thank you. Yes, I'm sorry. I was just stretching. I mean, you got tired. I'm sorry. Thank you very much.
Thank you.